Oral arguments completed in the prosecution against Michael Sussmann, former Hillary Clinton campaign lawyer charged with lying to the FBI. We're going to read what happened in court back on Wednesday, April 27th. We know trial scheduled for May 16th, and this was a very important moment. We were hashing through a number of preliminary issues, many motions in limine filed by Durham, the prosecution, and by the defense, Michael Sussmann, and they got it together in court to argue about it. You can see Judge Cooper was the judge presiding. He is the assigned, and we had a number of attorneys piling into the courtroom over there at the United States District Court. In there, the D.C. Circuit. You see the cases, United States of America against Michael Sussmann, seen here. Spent a lot of time talking about this guy. And the prosecution team is comprised of the following. We've got Andrew DeFilippis, Jonathan Edgar Algor, Michael Kilty, Deborah Shaw, and Special Counsel Office, all being led by, of course, John Durham, Special Prosecutor. They appeared in court. For the defense, we've heard from several of these people before. Sean Berkowitz, seen here, as well as Michael Bosworth, Catherine Yao, Natalie Hardwick, other people from Latham and Watkins out of New York, New York. Court reporter is there as well. Hello, Lisa. And the proceedings start as follows. We get into the courtroom. The deputy says, pipe down, everybody. All right, good afternoon, everyone. We're here for a criminal motion hearing in the following case against Michael Sussmann. We're going to start with counsel for the government, the prosecutors. Please approach the lectern, Mr. DeFilippis, and state your name for the record. He does that. He says, good afternoon, Your Honor. Andrew DeFilippis for the government. I'm the prosecutor here, as you know. With me at counsel table are assistant special counsels. We know who they are. Judge Cooper says, all right, well, good afternoon, everyone, and tells the prosecutor, Mr. DeFilippis, feel free to take your mask off if you're addressing the court. And it's kind of a opportunity, but it's also sort of a request. Feel free to take it off. It's sort of like, take it off. I want to be able to hear you. Prosecutor DeFilippis says, thank you, Your Honor, will do. Berkowitz now, for the defense, stands up. You see a photograph of him over here. He says, good afternoon, Your Honor. Sean Berkowitz, Michael Bosworth, Natalie, and Catherine, we're all here on behalf of Mr. Sussmann, who is also sitting there present in court. Judge says, good afternoon, Mr. Berkowitz. Welcome to Washington. And remember, last time he was calling in from New York. And Mr. Cooper, the Judge Cooper, said, I thought I was going to see you here in court. And he said, well, sorry, we're stuck over here in New York. So the judge says, good to see everybody in person for a change. All right, he says, lights go off or something. Says, I think someone forgot to pay the light bill up here. So something's going on in the courtroom. Judge says, all right. Well, we have quite a number of issues to get through this afternoon. What I thought would make sense is that we try to clear some away of the underbrush, and then we'll get into the bigger ticket issues there at the end. How's that sound? Everybody's, yes, Judge, nodding away. Why don't we start with the 404B notices and objections? We'll put aside the issue of gathering the underlying data. Says there was a number of objections that I think we can get through in fairly short order. Some of them maybe brief argument, others maybe just some clarifications. I think we can run through this. Everybody's nodding away. Sounds good, Judge. The first issue, there was an objection to certain aspects of the October 2018 public statements by Perkins Coie. As I understand it, Sussmann and the defense do not object to those press releases coming in or coming out as evidence of Sussmann's role in drafting those releases. But there's also an issue as to the testimony from the managing partner or other representatives of the firm. So we're talking about this issue from 2018. Apparently there were public statements by Perkins Coie, and the defense doesn't object to those coming in or to the role that Sussmann played in drafting those statements. So he goes over to the prosecutor. He says, okay, Mr. Prosecutor DeFilippis, first question is on to you. Do you plan on calling a representative of the firm, Perkins Coie, to opine on the releases or the circumstances or anything about these press releases about whether they're accurate or not? And the prosecutor says, yes, Judge, we do. I think we did put the former managing partner of the firm on our witness list. And I would say this is going to depend on how testimony comes in at trial. I think regardless, the government does not intend to spend a lot of time on this issue. But we think that if it is to come in at trial and if the jury is to know about the statements made by Perkins Coie, we think it is certainly relevant. And perhaps the core relevance of the statements are Mr. Sussmann's role in the drafting, approval, and issuance of those statements, saying that, if Perkins Coie was representing the Hillary Clinton campaign and the DNC and many other Democrats, well, and Sussmann was a part of that team, and he was somebody who was, saying to the FBI that he was proffering forward this information, not on behalf of anybody else, but he was, and we can prove that by some of the statements that was released by his own company, by Perkins Coie, that he helped draft, we can connect the dots. We can follow the bouncing ball from one thing to the other. But it's going to be relevant if they make it relevant. We're not going to spend a lot of time on it because there's a lot of other issues that are a lot more relevant. This seems like small potatoes, to be honest. But they want that option. The prosecutors want to make sure they have that on the list. And they say that. So I would say it's not a certainty, but we currently have him on the list. So we just want to keep him there. Court says, all right, well, we'll reserve that then. Any other testimony until trial. How about this? Do you plan on getting the billing records in through that witness or through another witness? If you're going to bring the managing partner in to talk about these press releases, is that also how you're going to get the billing records in, because the managing partner is responsible for those billing records? He says, well, Judge, Your Honor, the billing records would come in, we hope, through a stipulation and then published through a summary witness. We don't want to have to lay a bunch of foundation in order to get those records in. It's kind of just records in the ordinary course of business. We're hoping they just agree to let us get those in. We're going to stipulate to it. We don't have to go through a bunch of witnesses. Judge says, all right, Mr. Sussmann's testimony before the HSPCI. And I think what he's talking about here is the United States House Permanent Select Committee on Intelligence, where Sussmann was called in front of Congress and asked questions. But I think they may have gotten, and I could be wrong about this, but I think they got the acronym wrong. I think it would be the HPSCI. So HPSCI. Over here, we have HSPCI. I think that's what's happening. They just got the S and the P reversed in the transcript, but I could be wrong about this. It says here, Mr. Bosworth is here now back on the scene. We've heard from him previously. Says, any other related issues to the HSPCI? There was no objection to that from the defense when Sussmann came out and had to testify. Are you going to try to keep any of that out, or if he brings that up, or are you going to try to preclude that evidence or that testimony? Any other issues related to that? And Bosworth says, yes, Your Honor. So let me explain this as the defense. Mr. Sussmann doesn't object to the admission of the portions of the hearing testimony that are relevant. So he says, to the extent that he testified about the meeting with the FBI, the meeting with the CIA, who the client was, that kind of testimony is clearly relevant. Judge says, okay, right, yeah, it is. What we have objected to are certain portions of additional testimony that the special counsel has said that they want to offer, meaning Durham. They want to expand that scope a little bit and talk about some other stuff that we just don't think is relevant. We're good defense lawyers, and we're conceding that some of it's relevant, but we want to narrow this puppy down big time. He says, for example, if the prosecutors want to offer the testimony seemingly in toto to argue that Sussmann concealed his relationship with Clinton campaign, well, we might have a problem with that. So he's saying they can talk about it for certain purposes, but not for other purposes. If they're going to try to make this broad argument saying the totality of all the circumstances, all the indicia show there was this big conspiracy between Clinton, well, that's not appropriate. But if they're talking about the specific points he was making during his testimony, maybe that is relevant. But if they do try to promote this big conspiracy, he says, look, our position as Sussmann's defense team is there was never a question that was put to him that required him to answer, here's my relationship with the Clinton campaign. In other words, nobody asked him about this. So he had no affirmative duty to say, I'm here on behalf of the Clinton campaign. Nor, the defense writes, has Durham and special counsel identified any freestanding obligation that Sussmann had to disclose any relationship with the campaign, with the Clintons. First of all, the FBI didn't ask him about this at all, okay? So he didn't have to acknowledge it either. They didn't ask. He had no special duty to confirm it. So he's perfectly clear. So the defense says, so to the extent that they want to argue, here's another, bad act. In other words, this is just more meat to show that Sussman's just a generally bad dude. They say another piece of evidence of concealment of the client relationship. We think that's improper. There's no sufficient factual predicate for it. Judge Cooper says, all right, got your argument. And Bosworth says, go on. He says, go on. There are other portions, and the court jumps back in, says, well, I will let them ask, if this comes up, I'm going to let them ask, did he mention anything about the Clinton campaign? There's a witness on the stand, and they want to ask about that. I'm going to let that happen. He says, and if the answer is no, well, then you can clean that up on cross-examination and elicit the fact that he wasn't asked a direct question. So I'm going to allow the question and the inquiry on that topic because it's clearly relevant. Sussmann's there, and we need to know where this lie was. Was it a material lie? The defense says no. Prosecution says yes. Defense says it was a little white lie, had nothing to do with anything. It was about the information. Prosecution says it had everything to do with the information because his credibility was now at stake. If he's there on behalf of the Clintons, there's a big conflict of interest there. And that may have caused them to do their investigation differently, says the prosecution. And so here the judge is saying we can explore that definitely, because that's kind of a key point of this whole trial. If you want to clean this up on cross-examination defense, you can say, yes, but isn't it true that nobody ever asked him specifically if he was here on behalf of the Clintons? Isn't that true? Nobody asks that question specifically. Yes, that's true. Okay. Here, Mr. Bosworth. All right. Got that, Judge. Court says, and I don't think that's prejudicial at all. So you're just going to have to deal with that and let it be. Bosworth says, all right, bummer. Okay, the other portion, Your Honor, was the portion of the testimony that they seek to elicit about Mr. Steele and the Steele dossier. And the court says, perfect. Yeah, why don't we get to that? Bosworth says, exactly. Thank you, Your Honor. So the court says, okay, the failure to preserve the text messages on the defendant's iPhone. Is that still a live issue? Are we going to get into this still? I don't see anything in your concluding brief on that. Prosecution comes back on behalf of Durham, says, Your Honor, the government, I think, has decided we're not going to include that in our case in chief. Again, we reserve the right on rebuttal, but we don't intend to make a point of that in our case in chief. The fact that there was no preservation of text messages on Sussman's cell phone. In other words, it sounds like he just started fire selling his cell phone. Delete, 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 delete. Yes, refresh. Yes, factory reset. Yes, do it again. Make sure it's off the cloud. Check all of the different accounts. Verify your passwords. Delete everything. The court says, okay, evidence of the special counsel's alleged bias. Are we going to bring that up? Over to you, defense. Defense, are you going to raise that issue, saying that the special counsel is biased here, Mr. Berkowitz? And Mr. Berkowitz says, Your Honor, and the court jumps back in and says, apart from eliciting testimony as to the investigative steps that the special counsel may have taken. And Berkowitz, for the defense, says, correct. Okay. The court jumps down. He makes another ruling. The court says, all right, we got that prior issue understood about the texts. He says the Clinton campaign tweet, that tweet that they posted, I think it came maybe from Jake Sullivan, endorsed by Jake at least, who was a representative there for the Clinton campaign. And the court says, okay. Berkowitz says, and to the extent it reflects witness bias, Your Honor, in terms, and the court says, Mr. Berkowitz, look, I can barely hear you. I'm going to ask you to come up to the mic so the court reporter can pick you up. Speak up. He comes up there. He says, look, Judge, I think our carve-out, Judge, was to the extent that it could also reflect witness bias that special counsel Durham might have been investigating a particular witness. We could ask about that as well. Court says, yeah, that might be fair game, but we'll reserve until it comes in. Court jumps down to another issue, and we're going to pick up the pace here and sort of flash forward shortly. The court jumps down to another issue, says, all right. So moving on. The Clinton campaign tweet. Remember they posted that tweet, Trump-Russia collusion, in the weeks leading up to the election. Judge just comes out, doesn't even want to hear any arguments about it. Says the court will exclude that tweet as hearsay. Says, all right, prosecution, I know you're not happy about this, but to the extent that the government believes that it offers some sort of connection to the campaign and an attorney-client relationship, probably duplicative of other evidence, and the tweet will not come in, saying that really you can get other evidence that Sussmann was connected to the Clintons through Perkins Coie or something else. Hillary Clinton's tweet, a little too far removed from a connection to Sussmann specifically. Shows Hillary is Hillary and was doing a bunch of Hillary things, but we're talking about Sussmann here, and so it's a little too far removed, and it's a little duplicative, and so we're going to make sure that is excluded. We jump down to page 12. We see they're talking about redactions now, and what the jurors are going to see at the trial here coming up in May. It says, the judge is talking now, says, it seems to me, based on what I've learned so far, that you both are preparing your evidence, and you anticipate having witnesses and billing records, and perhaps other evidence from the prosecution showing that there was an attorney-client relationship between Sussmann and Hillary through Perkins Coie, which is where Sussmann worked, with all of the relevant parties. And the judge says, to the extent you would need a document or privilege log to show that there was this actual relationship and somebody asserted privilege, it seems like a lot of this might be duplicative. And there also might be some other things that are prejudicial to the defense if you just start like layering on all of these documents to show that there was a relationship here. He says, but we can see how all this plays out at trial. I may limit some of it as it moves forward. And the judge is now saying, we're done with this issue. Philippus, prosecutor, says, okay, thanks, Your Honor, we're done. But the defense stands up and says, Your Honor, may I be heard on this? The court says, Mr. Bosworth, what do you need? Bosworth says, can I be heard briefly on this redacted document issue? It's kind of a problem for the defense. Bosworth says, listen, court, defense says, our understanding is that to the extent there is relevant information in some of the redacted documents like emails and what special counsel seeks to admit, they said in their brief, who sent the email, who received it, and so on. He says, we're certainly open to stipulating to those documents about whether they can come in so that the jurors can see them. We don't have to fight over all of these things. He says, but we actually do think if the court will just permit me to pass up documents for the court's review, judge says, yeah, sure, send them up. So those documents go up. The judge takes a look at them. And he says, look, Your Honor, what you're looking at, we actually think the character of the redacted documents is prejudicial. Just looking at the redacted documents itself is harmful to our client, Mr. Sussmann. Why is that? Well, he says they look like this. They've got huge black boxes on them. And if you're an inquisitive juror, you're sitting there wondering, you're like, well, what's underneath that? There's a lot of stuff that's being hidden from me. I'm a juror. I'm supposed to be ruling on this case. And they put me here to make a decision based on all the relevant, pertinent facts and information. And then they're not giving me any documents because everything is totally blacked out. Defense says that's ridiculous and it's going to prejudice my client. Judge is listening to the argument from the defense, which continues. He says, we think we can sidestep that problem completely. To the extent that there are documents with relevant non-privileged information, we're happy to stipulate to that with the government, but we think putting documents like this in front of the jury confuses the jury and might prejudice Mr. Sussmann. So the defense is trying to really limit what the prosecution is able to show, is able to proffer forward to the jurors, saying, the redacted documents are harmful. We're willing to agree to certain portions, but we don't want the big black redacted areas included. And the prosecution maybe wants those included because it does exactly what the defense is saying, is it sort of leaves the jurors going, oh, I wonder what's behind that. Why can't we see that? The court says, all right, good point. We fight over this type of issues a lot. Says, all right, well, look, as you know, each side is entitled to prove their case through their evidence of their choosing if there's no stipulations. So if you guys can't agree on this, well, we're just going to have to see what gets offered as evidence. He says, even if one is offered, I get the point about a document like this with 2 pages of redactions. So we can get around that just by, having it excerpted or having something in ellipses or an indication that the body of the text has been redacted or something. And Bosworth says, all right, works for me. Good enough, Your Honor. I raise my issue. Moving on. Court says, all right. The full transcript is 56 pages. We're jumping down, fast forwarding to page 34. Here they're talking about very important concept about co-conspirators and about things called joint ventures and whether or not Sussmann and the Clintons and the DNC and Perkins Coie and all of these people were involved in something that fits under one of these categories. And so the prosecutor, Mr. DeFilippis, comes out. Now we're on line 20, page 34. Says, all right, Judge, listen, let me just distill all this down for you. And it's a nice summary of what's going on. He says, just to distill it down to a category of each people, the thrust of this joint venture of all these people was that there was a decision and an effort to gather derogatory internet-based data about a presidential candidate, Trump, about a presidential candidate among these folks. There were researchers who began doing that, Rodney Jaffe, tech executive number 1, it seems, before Perkins Coie became fully involved. And there are emails we will offer that show the data was being pulled in late July and August, in the months right up to the election. And we looked at some of those emails on our headline show. Make sure you check those out as well. Says, so the researchers were the engine of this joint venture in the sense that they were doing the work, and they were doing, the emails make clear, they were doing it for the express purpose, which we read these emails that were going from these researchers back over to Rodney Jaffe, finding derogatory information in the internet data. So that's one category of people. And he says, and those folks, whether they at some point developed hesitations like research number 1 did, when he was saying, maybe we all just hate Trump too much and we're sort of off the course. We can't manufacture something that doesn't exist because our political opponents are going to be able to deconstruct that. He says he was, at the end of the day, one of the most reluctant when Mr. Jaffe circulated the white paper that Mr. Sussmann would bring to the FBI. Says it was sort of a wink and a nod to request for a comment. Look at this paper as a non-expert. Anybody would see it's essentially not going to pass muster. And researcher number 1 said, nice job. I think a non-expert would buy it, essentially. So at the end of the day, he was willing to advance the goal. All of that under the purview of Rodney Jaffe. We also have, Your Honor, as he continues to follow the bouncing ball, connecting the dots, the members, Clinton campaign lawyer number 1, a general counsel to Clinton, and Fusion GPS, Mark Elias played critical roles in pursued similar goals in the joint venture insofar as Mr. Jaffe was connected to Fusion GPS and lawyers from Perkins, like Mark Elias. The emails reflect very clearly that the VIPs had desires. And remember, Rodney Jaffe was saying that in his instructions to the researchers. VIPs would be very happy if we're able to find some of this material. They wanted this internet data to be pulled for this purpose. And Mr. Jaffe, in a classic joint venture form, tells the researchers the VIPs would be thrilled if they could support this inference and this narrative. So the prosecutor says, look, wrapping up his argument, says, so, Your Honor, this is a classic joint venture in the sense that you have the VIPs, meaning Perkins Coie, and the Clinton campaign. You got Mr. Jaffe as the client, the intermediary. You have, the lack of a better word, the worker bees, the researchers bringing the data in and funneling it into the effort. So all of that we think is well within the bounds of the law insofar as it does not have to be criminal, and insofar as each member of it doesn't have to have full involvement. Not every single person has to be involved in every facet of the conspiracy, of the joint venture. Just a little involvement is enough. He says, so for example, researcher number 2 said that he has said that he was not aware that the campaign was involved, but we have a CEO of a tech company who initially ran some of the data for Tech Exec 1, Richard Jaffe, who said that Jaffe told him expressly, I'm working with a DC firm with ties to the Clinton campaign. And so he says, we just think on the bare facts, judge finally, okay, I've heard enough. It's fairly clear. Judge chimes in, says, assuming that I agree that it's all relevant, you could get that in by calling witnesses without the emails, right? Certainly some of it, Your Honor. You could admit it through the witnesses, right? Okay. Court says, okay. Thanks for your argument, prosecutor. Mr. Berkowitz, the defense, over to you. He says, all right, Judge, make no mistake. These emails that they don't want in are being offered for the truth. And he says, I think that's the most. And the court interrupts him, says, for the truth? What? I mean, obviously, they're not all being offered for the truth of the exact words, because some of them are, the government disagrees with or would not stand behind. So slow down there, Mr. Berkowitz. What do you mean all of it? Let's dial in on that point. He says, what's the truth that they're being offered for? Berkowitz says, all right, Judge. You want to tango? Let's tango. Says they're being offered, as Mr. DeFilippis suggested, to tell this larger narrative about some type of conspiracy that they read into the documents. It was, very subtle, but he said it's to please the VIPs, which of course are Perkins Coie and the Clintons. They're not in the documents. They're being offered to suggest and imply that there was a relationship, and it's to craft this big narrative. And so what we're saying is that it's not appropriate. They want to fill in the context, but just because they want to fill in context doesn't overcome the hearsay burden if they're trying to get these documents to say that Mr. Sussmann was a liar. Well, that's an out-of-court statement, and if you're trying to bring that in here, we don't have the same integrity concern. We have integrity concerns, and if you're trying to bring a statement like that into court to prove the truth of the matter asserted, we have integrity concerns about that. And we have rules that say that's hearsay and it needs to be eliminated. So the judge continues, says, Judge, we're not going to contest that there was an attorney-client relationship. And so the defense really summarizes what they're arguing here, saying the concept, right? What we're talking about here, we cannot unmoor from the actual charge. All this stuff is incidental. It's not really relevant to lying to the FBI. He said he's charged with lying about whether he had a client when he went to meet with the FBI or whether he was there on behalf of the client. The reason that Mr. DeFilippis, Durham's prosecutor, suggests all these things are so relevant is to establish that Jaffe was the client, and they wanted to hide the fact that that information was gathered and collected in a particular way, or there were concerns about it. What do we know is undisputed? That Mr. Baker will testify that Sussmann, Baker was counsel for the FBI, is going to say that Sussmann said the information was from cyber experts, not whether it was a client or not. It came from experts, and the FBI didn't ask him about those. Who were the cyber experts? Did they follow up? Nobody asked him about that. Nobody even spoke with Mr. Sussmann. It was James Baker, general counsel, who then gave the notes over to Trish and Bill. So what they're trying to do is just limit what evidence comes in. The defense is saying none of that stuff is relevant, and it's important that they win these arguments because it makes their client look bad. And the judge finishes, says, well, to be fair, I think their theory, the prosecution, is that despite the fact that Sussmann's not on these emails, his involvement in meetings and correspondence, same people, same time before the meeting, creates that inference that, he was a knowledgeable person about and involved in the operation that they were engaging in. And therefore, because he was in the joint venture, any particular joint venture statement is admissible under the hearsay exception. So that material can come in because it's part of the same underlying joint venture. The hearsay rules, as the defense are arguing, would keep that out ordinarily, yes, but there's an exception to that because you can't be a part of a joint venture and have all these conversations involving your conspiracy and your illegality and then say, well, you can't talk about that. You can't use that evidence against me because it's hearsay. You say, well, gosh, that's true. I guess he beat us at our own game. Well, the rules are smarter than that. They say, no, there's an exception to those. Yes, it is technically hearsay, but we're going to allow that in because it was part of the joint venture. And that's kind of one of the charges that you need that information to prove. So you can see the judge is just weighing a bunch here. And we fast forward to the end. The court closes it out. The judge says, okay, well, anything else, counsel? Prosecutor, of course, says, Your Honor, just one more thing. Says, we just want to confirm. On the CIA meeting, is it the correct understanding Your Honor is going to set parameters on that? Which is not entirely clear. Court says, yes, we're going to get clarity on that, Mr. Prosecutor. Take it easy. Says, okay, thank you, Your Honor. Just wanted to make sure. Court says, yes. And we set a date for the privilege assertion, right? We're coming back here on May 4th is what that looks like. Court says May 4th. Now the defense has something else. They say, Judge, we're coordinating with counsel on the privilege assertion side. Hopefully we can, do all this in less than an hour and try to make it as easy as possible. And the court says, all right, yeah, perfect. If you could streamline the argument to the extent possible, there's a lot of overlapping issues, I think. Make it very easy on me. Defense says, yes, Judge. And I think that everybody will be ready for questions that you have. And the defense says, Judge, you do a really nice job, I can say, of focusing the issues. We'll try to make sure that the people are prepared to do that. The defense buttering up the judge. Excellent job today there, Judge. Fascinating conversation with you, investigating these very pertinent issues. Court says, all right. Berkowitz says, the only other issue, and the court calls him out, says, flattery will get you nowhere. Berkowitz says, my audience of one for the time being, I guess. The only other issue, Judge, is in light of the order that you issued, we very much appreciate last Friday in a timely fashion. More buttering up. It raised some issue about the scope of what the expert will say. It says, we've asked special counsel to provide additional disclosures, what they will say. They've indicated to us they're putting all that together. And if we have to seek your intervention, Judge, if we need you to go over there and backhand the prosecutors because they're not giving us our constitutionally mandated disclosure, we'll come knock on your door, Judge, but we're working with them in a professional way. These guys are laying it on thick here. Pretty amazing. He's paying forward compliments to the judge, and then he's also sort of backhanding the prosecution at the same time. That's what you get when you pay for powerful New York lawyers, I guess. Really nice skill set, not obvious at all. The court says that's fine, as you know, inevitable. Some of this should wait for trial. And Berkowitz says, that's rapidly approaching, Judge, coming up May 16th. Court says, all right, I think that's it. This matter, he announces, is taken under advisement. To the extent the court has not already ruled here today from the bench, we're going to stand in recess. Have a good day. We'll be back here shortly in May for more on privilege. And there's been just a whole litany of motions filed back and forth. We've been covering this in depth. If you want to stick around and follow and join us on the journey, I would love it if you hit that subscribe button because we're going to be paying a little bit extra attention on the Sussmann Durham prosecution because we've got trial here in just a couple short weeks. So I hope you do decide to join us. I would love it if you shared this video with a friend or family member and invited them to join us as well because I look forward to seeing you and them on the next one.